Good morning and welcome to this charity webinar. We're going to talk to you this morning about trade unions for charities. My name's Jo Oliver. I'm a partner in the employment team at VWV, and I'm joined this morning by my colleague Cathy Halliday, who's also a partner working out of our Birmingham office. So on the screen, you'll see an overview of what we're going to talk about. So we'll be setting the scene, talking a bit more about the interaction between trade unions and charities, trends and themes that we're seeing develop. We're going to talk about trade union recognition, the importance of a collaborative approach, when agreements can't be reached and when things become a dispute, how those things can be addressed. We're going to talk about industrial action, and Cathy's going to look at some practical tips to avoid escalation into dispute, and what does the future look like in terms of charities and trade unions. So if we can go on to the first slide, please. So if we set the scene, over recent years, we've seen a rise in trade union membership within the sector. We've also seen an increase in trade unions seeking voluntary recognition from charities, and some fairly prominent and large charities do recognise trade unions. In recent years, the Joseph Rowntree Foundation has recognised Unite, Action for Children recognises Unison and Unite, and the Civil Society undertook a poll fairly recently and asked 5 of the largest charities in the UK whether they recognise trade unions. And 29 of those charities responded, and almost half of those confirmed that they did recognise a trade union. So trade unions are working within the charity sector and play an important role in staff engagement. And I think that's something that is likely to perhaps grow further. And there certainly has been an approach of collaboration in the past. Some charities and some employers more generally can be a little bit wary about trade unions and whether that will recognition will work for them, or whether it might pose any kind of barrier in relation to getting things done or pushing through changes. There might be some reservations about how effective that can be. And there's not a one-size-fits-all arrangement here. In some cases, it would be really productive and helpful. In other cases, it might not work for a particular charity. So we're going to look at some common themes and look at some advantages, some disadvantages, and what's at stake. So charities and trade unions do occupy some common ground. At the heart of most charitable endeavours and at the heart of trade unions, there is an attempt to seek social justice and to effect change for the benefit of the charity or the trade union's beneficiaries or members. So there's that common interest in place. Both charities and trade unions also rely on volunteers heavily. So that, again, there's a common theme there. They rely on non-paid bodies to oversee their strategic directions and governance. And they both operate in heavily regulated forums. And so are used to working within that regulatory framework. So advantages of trade unions, they give an opportunity to enhance communications between employers and employees. They can have a positive impact on teamwork and collaboration. They can also be positive in terms of staff recruitment and as a retention tool, because recognition can be an indicator that your charity is an employer that values employee engagement and treats its staff well. And in the absence of existing employee representatives, such as a work council, recognising a trade union can help streamline consultation processes. So in circumstances where there might be a TUPE transfer or a collective redundancy exercise, having a recognised union in place would mean you wouldn't have to go through a process of electing your own staff representatives for those collective consultations. So having recognised trade unions in place can help streamline those processes. And also, introducing changes might be easier if you've got the support of a union, and the union can speak to its members about the benefits of those changes. And so it may help to bring some objectivity to internal discussions and help facilitate change. Also, because trade unions work across sectors and with other charities as well, they can bring their experience and share their best practice approaches that they've obtained from work with other organisations, and bring that knowledge to the work that they do with your charity, which can help in terms of improving policies and procedures, and generally in terms of introducing improved engagement. So those are some of the positive aspects. And to balance that, if we look at some of the potential disadvantages from trade union recognition, there is perhaps a perception that unions can be obstructive or difficult. There's a perception that perhaps unions can sometimes make unrealistic demands that don't look at the particular nuances of your charity, what you can actually afford to deliver, what you need to do in order to be able to meet your charitable objectives, that they're thinking more broadly about an agenda nationally than perhaps what you can do with the resources that you have and the obligations that you have in terms of good governance in delivering your charitable objectives. And so that can sometimes feel a bit of a rub and a bit of a conflict. So in those circumstances, there might be a disadvantage of trade union recognition. But equally, working with representatives from trade union representatives within your own workforce, they will know and understand some of the pressures that you're under and should hopefully be able to look at things from that lens. Another potential issue in terms of what could be seen as a disadvantage is that negotiations can sometimes be exhaustive without there being an agreement reached. So it might be that a lot of time and energy has been invested by you and by the employee representatives on your consultation committee in trying to reach agreement. And at the end of that process, it can feel a bit unfulfilling if you haven't got to that point, you haven't reached agreement, and then where do you go from there? And that's something that Kathy's going to talk about later in the session. Also, there are issues around threats of industrial action if agreements can't be reached. And that obviously is a matter of concern for management within a charity, because you obviously have services that you need to deliver. You want to offer continuity in relation to those. You want to make sure that you can continue to deliver on your charitable objects. And so having staff withdraw their services through strike action, for example, can be a really challenging period for you. And then another issue is what happens in circumstances where the relationship with a trade union that perhaps started off well turns sour. Could it be that that becomes a barrier to change? Could it be that the charity becomes less responsive and dynamic in terms of being able to implement the strategic changes that it needs to make? And so there is a concern that sometimes that you may be prevented from moving forward by the arrangements that you've had in place with a trade union. So when we look at what's at stake, positive staff relationships really are the key thing that is at stake here. If your staff are giving or have a mandate to be represented and want trade union recognition, then not listening to that voice could impact employee engagement. Looking at the ability to get things done in the smoothest possible way. Again, that's at stake in terms of looking at how you engage with trade unions, and the charity's reputation amongst staff and wider stakeholders. There might be a perception that your charity doesn't treat staff fairly if it doesn't recognise a union and staff are members of that union and want recognition for their union. So if we move on to the next slide, please, Romany. So if we look at what's meant by recognition. So recognition is a process by which a trade union is recognised by an employer as entitled to negotiate on matters such as pay on behalf of workers in a particular bargaining unit. So a bargaining unit can be the whole workforce or made up of workers holding agreed job titles or working within a specific area of the charity. And it's important to be clear on who is going to be affected by collective bargaining and who is going to be, whose terms and conditions will be changed by decisions made through collective bargaining. So that's why it's important to understand who's in the bargaining unit, so that both the staff involved, the charity and the union know who they are negotiating over, and what the impact will be on those individuals. So negotiations with a recognised trade union are known as collective bargaining. The terms on which a union is recognised and the process that it will follow for collective bargaining is usually captured in a recognition agreement. This can be a really useful document to record the stated aims and approach of both parties and the mechanism of how any proposals will be agreed. Recognition can be through both voluntary and statutory processes. Most trade unions are recognised on a voluntary basis, but in circumstances where that can't be agreed, statutory recognition can be applied for by a trade union, and we're going to come on to that in a moment. So if we move on to the next slide, please, Romany. So if we look quickly at the differences between voluntary recognition and statutory recognition. So voluntary recognition is in a sense more flexible, because you're agreeing to it on a voluntary basis. Both you and the union can agree, the bargaining unit can agree the scope of the topics that you're going to negotiate or consult on, and voluntary recognition can be withdrawn at any time. So there is an element of flexibility about it, and you can set your own mechanism for how you're going to go about consultation and negotiation. Whereas statutory recognition is more rigid. It's a statutory framework that's set in place if the parties can't agree how the trade union is going to be recognised and on what basis. So it comes around from a formal request, and primarily negotiations are restricted to pay, hours and holiday unless the scope for the areas covered is agreed to be wider by the parties. And if statutory recognition is approved, a set mechanism with a 6-stage process is put in place for how you go through the negotiation process. And it can be quite legalistic, and it can feel quite a rigid process. So if we go on to the next slide and look in a bit more detail about the process for recognition. So as I mentioned, voluntary recognition, it normally comes about from the charity making a request to the trade union making a request to the charity to be recognised, and that request would usually come in writing, and it would generally identify which staff the union wants to represent for collective bargaining processes, and the areas it wishes to negotiate on. So it might cover pay, working conditions, workforce changes, training, recruitment, job descriptions, job evaluations. They might list a whole number of things that they'd like to be recognised in relation to, and then it is up to you as a charity whether you accept, seek to negotiate on what the proposal is, or whether you reject the application or the request for voluntary recognition. You need to respond. It's not something that you can ignore, and it makes sense to explore it and to see whether there is support from the staff before making any decision one way or another. If the voluntary recognition request is turned down, then the route left to the trade union is to go down the statutory route, and then you could find yourself having a process imposed on you rather than agreeing something that actually works for your charity. So even if there are reservations about voluntary recognition and whether it will work for you, if a request's made, it makes sense to explore it further and look into it and be seen to be looking into it in a meaningful way. Because if staff who are union members take part in an indicative poll, for example, arranged by their union, and there is some sign of support for recognition, not to agree it or not to be seen to putting some form of consultation arrangement in place could affect staff morale, could affect relationships with your workforce. So in circumstances where voluntary recognition isn't agreed, the union can apply to the CAC, the Central Arbitration Committee, for recognition. It has to make a valid request to the charity first, and that means it has to be in writing. It has to be it has to identify the bargaining unit of the staff that it proposes to represent. And you, as the employer, have 10 working days then to confirm whether or not you accept the request, whether you wish to negotiate on it, or whether you reject it. If you wish to negotiate, you get a further 20 working days to try and agree the bargaining unit and what will be covered. And you can use the services of ACAS to assist you in reaching agreement. But ultimately, if agreement isn't reached or if the request is rejected, then the trade union can apply for recognition to be imposed. And they'd need to show that they have at least 10% of the proposed bargaining unit are union members, and that they've got support of the majority of those employees within the bargaining unit to get over the initial threshold for their application to be accepted by the CAC. And then the CAC may assist the parties in determining what the bargaining unit is. So if it's not entirely clear from the initial request, or if there is any objection or wish to redefine the bargaining unit by the employer, the CAC may assist in helping to determine that bargaining unit. And also the CAC may assist in terms of organising a secret ballot to make sure that those who are within the bargaining unit have given a mandate for recognition. So they'd need to make sure that at least half of those entitled to vote, and out of the bargaining unit, 40% are voted in favour before the CAC will grant recognition. So if we move on to the next slide, please. So if we look now at what the consequences of recognition are, so whether you have recognised a union voluntarily or whether they're recognised through going through the statutory process, once they have been recognised, they gain certain rights, including the right to information for the purposes of collective bargaining. So this is information that allows them to put forward an informed proposal for collective bargaining, so an informed proposal on pay. So they might want information in relation to the financial position of the charity, or information about staff and recruitment, and they're entitled to certain information to allow and facilitate collective bargaining. Recognised trade unions are also have the right to consultation in the event of collective redundancies. So if 20 or more dismissals through redundancy are proposed, they have the right to be consulted in relation to that. And similarly, in relation to TUPE, they have the right to be informed and consulted in relation to any TUPE transfers, so that they can put forward representations from the employees affected. And there are also rights for officials, learning representatives and other members for time off work for union activities, and certain protections exist for union members and union officials taking part in various union activities and also in industrial action. So if we move on to the next slide, please. So we talked about the importance of having a recognition agreement, and now we're going to look in a bit more detail about actually what's in the recognition agreement. So for statutory recognition, generally it's limited to pay hours and holiday, and there's a default mechanism for collective bargaining. And that's a 6-step process that has certain time limits and is quite rigid in how it comes across. For voluntary recognition, there's much more flexibility in what is included in your recognition agreement. And this allows you to include the stated aims of your charity and its interactions with the trade union. So setting out that you intend to have a collaborative approach, that you respect employees' rights to join and become a member of a trade union, that the trade union recognises your right as an employer to have a relationship with your employees, and that it shouldn't unnecessarily interfere in that relationship in the day-to-day context. So setting out some parameters and aims at the outset of a recognition agreement is quite helpful to add clarity to the relationship. A voluntary recognition agreement should also be clear in identifying who the bargaining unit is to avoid any future disputes or uncertainty about who's covered. So stating clearly what groups of staff are in the bargaining unit. So it might be those holding a certain job title, might be those working in a particular department or a particular area. And so making sure that's clearly defined to avoid any ambiguity is really helpful in the recognition agreement. And then a key point for any effective recognition agreement is making sure that you cover the scope for information, consultation, and negotiation. So when and how will information be provided? What level of information will be provided? How long before certain activity will that information be requested? And then what topics or areas will be covered by negotiation and what will be covered for consultation. And there's a clear distinction between the two. So with negotiation, you're committing to trying to find an agreement at the end of that process to try and reach an understanding to implement change. Whereas with consultation, it's an exchange of views and that there's no obligation on you as the employer to accept the views of the union, but there's an expectation to give them proper consideration before implementing any changes. So it may be that within your recognition agreement, you're setting the topics that you will negotiate on, and that may be the core pay, hours and holiday, the same as statutory recognition. And then you may be more comfortable consulting on a wider range of topics, such as recruitment, staff retention, job descriptions, policies. You may feel that you're more comfortable having a consultation arrangement for those and negotiating on those core terms. And having a clear definition of what's covered by negotiation, what's covered by consultation, again, is really important for clarity and avoiding any dispute. And having that certainty in the arrangements and how you're going to go about them aids effective communication and effective employee engagement. The recognition agreement would also set out who can be a representative and what the membership of the consultation committee will be. So how many from the employee side, how many from the charity side, who will be chair, what's the quorum of a meeting, the practical arrangements for how long someone sits on that committee, if there are any circumstances in which they can no longer act as a representative. All of that can be defined in your recognition agreement to provide certainty of those arrangements. And then, most importantly, the mechanism for collective bargaining, how that's going to happen. So when you're negotiating, what is the process that will follow? So how frequently will you go through rounds of negotiation? Will it be annual? Will it be more? How that process will start. So will it start with a proposal from the trade union on pay, hours and holiday? Or will it start with a proposal from the employer? Or can there be an arrangement either way? When the meetings will take place, how many meetings that you'll have to try and reach agreement, and then most importantly, what happens to bring that process to a close. So being really clear on when the collective bargaining process has come to an end and when the process has been exhausted is essential in for you as an employer to be able to show that if you're making any direct offers to staff at the end of that consultation process, because if there is any uncertainty that collective bargaining has been exhausted, any direct offer might be seen as an inducement, and there may be a risk to the charity from making proposals directly to the staff if collective bargaining hasn't come to a complete end. So having that clarity in your agreement when it ends is really important and really helpful for effecting change, and not meaning that negotiation drags on when there are no real prospects of it coming to agreement being reached. And then also including how any disputes are going to be resolved is really helpful. So whether that might be going to ACAS or another form of mediation, for example. And Kathy will come on to talking about trade disputes shortly. But setting out how you're going to resolve disputes, again, is helpful in managing the relationship and setting expectations. And then putting arrangements in place for facilities. So providing meeting rooms, time off for training, and other facilities like administration support or access to staff for the trade union reps to actively go about their work and be supported in doing so. And also, the recognition agreement can make an important statement around confidentiality. So what's expected of the parties and the representatives attending meetings? At what point can they share information? At what point is information still confidential to that group? Just so that there's no accusations of leaks, and it aids transparency in those meetings. So setting those parameters, again, can be really helpful. If we go on to the next slide, please. And so a collaborative approach is essential for trade union recognition and any employee engagement. The value of having bespoke recognition agreements is high to charities, because having that agreed framework of how you're going to negotiate, what you're going to negotiate or consult on, can be a really positive thing in terms of how you convey decision making to your staff. It can make staff feel that they are being listened to, that they are being heard, that there is a mechanism for change that does include their thoughts and views. It can be a really useful process. And having bespoke agreements that set out clear procedures, I think, avoid the potential for dispute, for uncertainty, and show a clear time frame and a timeline of getting things done. And that can be really helpful, particularly when changes are necessary. And it aids effective communication. Of course, trade union recognition isn't the only way of having productive staff engagement. There are alternatives. So many of you might already have staff forums that are effective and work well, and you may feel that there's not a need to introduce another element to that with trade union recognition. And if you feel, and the feedback that you have from your staff is that they feel that they are being heard and represented, you may feel that actually adopting trade union recognition isn't for you at this particular time, and that's perfectly okay. As I said at the beginning, there's not a one size that fits all. And if you have a works council and you have a good relationship with them, you might not want to add another element in there that could upset that balance. Also, if you don't believe that there is significant trade union membership within your workforce, you might have concerns that there isn't really a mandate for recognition, and that others might get swept along who are non-union members in any recognition and not feel that they're being heard or listened to. And obviously you want to engage with all of your staff. So if you're worried that it wouldn't be representative, then perhaps trade union recognition isn't for you. And as part of the process of exploring voluntary recognition, you might want to know if there are any indicative polls from the staff or other indicators to see whether union recognition is something that they want or feel that they need, or if there's an alternative that they would prefer. And some employers are concerned that recognition can lead to a fragmented workforce, because if you break down your workforce into various bargaining units, it may feel that you're negotiating different terms, different times with different groups, and some people may feel left out or feel that they're being treated in different ways that aren't equal. And so you might prefer a more holistic, all-staff approach by introducing your own employee forum that takes representatives from all areas of your workforce to consult as one, rather than that fragmented approach that may not be the best for your charity. So if we move on to the next slide, please. And I'm going to hand you over to Kathy.
Thank you, Jo, and good morning, everyone. So what happens when agreement can't be reached during negotiations and a resolution hasn't been agreed if you are using a disputes procedure? So if the failure to agree relates to a trade dispute, then one possible course of action is industrial action. And in seeing whether that's a possibility, the first thing to consider is what is a trade dispute? So the definition is quite broad. It's a dispute between workers and their employer, which relates wholly or mainly to one of a specific number of categories of things which are set out in the statute: terms and conditions of employment, engagement, termination or suspension of employees, allocation of disciplinary matters, trade union membership or the facilities, and the machinery for negotiation. And by far the most usual course of dispute is about terms and conditions of employment, and particularly pay. Because the definition is very broad, it's really rare for a successful challenge to be made that the dispute that's arisen does not relate to a trade dispute. Next slide, please. If the dispute falls within the definition of a trade dispute, then the next thing to consider are the balloting requirements. And a lot of trade union law is really quite detailed and procedural, so apologies, but it's important to understand the framework that applies. So firstly, the union has to give a notice of ballot, and that has to be given at least a week before the ballot is held. And the employer must also be given a sample ballot paper at least 3 days before the ballot. Now, the ballot paper has to set out some specific information and some certain wording, but the highlights include it has to set out a general summary of the matter or issues in dispute between the parties, the type of industrial action, so is it going to be strike action or action short of a strike, which is action such as an overtime ban, and when they're balloting, unions often go for both types at the same time, in the alternative and together. It has to set out who is authorised to call the strike action on behalf of the trade union, the convener, and it has to give the time frame when the industrial action is expected to take place. The ballot has to be held by a secret postal vote, and it's a requirement that all of those trade union members who are being asked to take the industrial action are eligible to vote, and no one else should be asked to participate in the ballot. So obviously non-union members are not asked to participate in the ballot, and other union members or people in different bargaining units should not be asked to participate in the vote. However, after a whole series of cases, it's been concluded that minor administrative errors will not invalidate the vote. So that's one area of challenge that's been sort of removed more recently. So how is a ballot successful? So for the vote to be passed, at least 50% of those eligible to vote must actually have voted. And the majority of those who vote must actually support the industrial action. So if you have 100 employees, at least 50 must vote. And of that 50, at least half must support it. So you'd have to have 26 voting in favour. So you can see that industrial action could be voted for by quite a relatively small proportion of your union membership, and that could be an even smaller proportion of your workforce. There's a separate hurdle that needs to be overcome if the services affected are important public services, so that's certain health, education, transport, and also fire service and border security. In those occasions, there is an additional threshold that at least 40% of all those entitled to vote must actually support the industrial action. It is then a requirement that the result of the ballot must be published as soon as possible. Reasonably practicable is the test, and that is something that there have been successful challenges mounted to trade union action on the basis that it hasn't been published as soon as reasonably practicable. And there's also a requirement that a scrutineer's report must be provided if more than 50 trade union members are entitled to vote. If the ballot is successful, a further notice of 14 days must be given of intention to take industrial action. That notice must be in writing, and it must set out which employees by category and number, but not by name, may strike, and where they are based where relevant. It must set out whether the action is continuous or discontinuous. It must show the type of action, so that could be a strike, it could be action short of a strike, such as an overtime ban or a work to rule, provided that was covered by the ballot. And if it's continuous action, it has to set out the date the strike will start, or if it's discontinuous action, the dates when the action will take place. And I think we're all too familiar with these options in relation to the recent industrial action by the railway unions. There's been discontinuous strike action on the notified dates, and there has been discontinuous action short of a strike by way of an overtime ban by the train drivers, which has also impacted on the services. So what can an employer do to challenge or prevent industrial action? So other than all the good collaborative approach issues that Joe talked about earlier, if the balloting or notice provisions are not complied with properly, then the employer could apply for an injunction to prevent the industrial actions. These are quite technical injunctions, usually around the balloting requirements. However, if the detailed requirements have been met, then there is very little that an employer can do when threatened with strike action other than actually settle the dispute. Although failing to turn up to work is a breach of the contract of employment by the employee cannot be dismissed for going on strike. They're protected for going on a lawfully organised strike. And the trade union is also protected against any claims made against them. So effectively, the employer has no remedy if a lawful strike is called. Next slide, please, Romany. Now, we always like to refer to at least one case in the webinar, and today's case is Mercer and against Alternative Future Group. And this case relates to whether an employer is protected against being subject to a detriment for taking part in industrial action. Now, this case has gone all the way to the Supreme Court, which has concluded that while an employee cannot be dismissed for striking, they can actually be subjected to a detriment for striking, as there is effectively a gap in the protection in the UK afforded them by the current legislation. So this was potentially good news for employers, but the Supreme Court then also went on to conclude that the lack of statutory protection breaches the right of freedom of assembly under Article 11 of the European Convention on Human Rights. So just to give you a little context, Mrs. Mercer was employed as a support worker by AFG, Alternative Future Group, and was a workplace representative for the trade union Unison. She was involved in planning strike action, and she gave media interviews about the strikes, and she participated in the strikes herself. She was then suspended from work and was told the reason for her suspension was for abandoning her shift and speaking to the press. So ultimately, her suspension was lifted and she was actually not dismissed, but she was taken through a disciplinary procedure and she brought a claim under the Trade Union Labour Relations Act, TULCRA, which says that it is unlawful for an employer to subject a worker to a detriment for taking part in trade union activities. And she said being subject to a disciplinary process was a detriment. Now, she had to bring the claim on the basis that it was a detriment for taking part in trade union activities, because there's a gap in the statutory protection given to individuals who take part in industrial action. So TULCRA protects workers from dismissal only for participating in industrial action, but against detriment and dismissal for participating in trade union activities. So she was trying to argue that the suspension fitted into trade union activity box and not into an industrial action box. So it went all the way through the courts, and essentially the Supreme Court, agreeing with the Court of Appeal, said that actually there was a gap in the statutory protection and Mrs. Mercer could not succeed in her claim because she wasn't protected. However, the Supreme Court went on to make a declaration of incompatibility. They said that they'd identified a gap in the legislation that could not be rectified by the courts. And what this means is that they've brought Parliament's attention to the gap in the law, and Parliament could now legislate to fill that gap in, which is probably more likely if Labour win the next general election. It doesn't help Mrs. Mercer though, so she's still lost her case. So leaving our mini case update and returning to the proposed industrial action, we've identified the basis of a genuine trade dispute and the required and detailed ballot and notice requirements. So if these are all in order and a valid notice of strike action has been given, what can you do as an employer if employees do actually go on strike? Next slide, please, Romany. So you can use any existing agency staff that you've already retained and reallocate them to cover striking workers' duties. You can use your own bank staff if you have them. And you can reallocate employees from other parts of your organisation to cover striking colleagues. And clearly you either need to get their agreement to do that, or on some occasions their contract might allow you to require them to do that. You can also manage holiday requests to ensure that non-striking staff are working on strike days. So you can refuse applications for holiday if there's a strike day, and just to make sure you have more staff in. However, what you can't do is go to an agency, employment agency, and ask for additional agency workers specifically to cover a strike. There's been some toing and froing on legislation about that, but the previous legislation which allowed you to do that, didn't allow you to do that, was repealed, and then that repeal was overturned. So currently you cannot go to an agency and ask for additional agency workers. You also cannot self-evidently threaten staff if they go on strike, or bribe them, make them an offer of financial remuneration to come into work. And as already identified, you can't dismiss staff for striking. It's worth remembering, of course, that striking staff do not, of course, get paid when they're on strike because they're not working. And it's also worth noting that a union doesn't have to be recognised by you for strike action to take place. Union members can take strike action in your workplace even if you don't recognise that trade union. And that non-union members who are affected by the same trade dispute may also choose to strike, even if they did not vote in the ballot, as they're not entitled to do so. So strike action can affect you whether or not you recognise the trade union. Next slide, please, Romany. So strike action is self-evidently disruptive. So how can you avoid it? So as Joe's referred to, if you have an active trade union, whether it's formally recognised or not, you do need to invest in building a positive and long-term working relationship with that trade union. If you've chosen to have a staff forum, you need to engage with that. And if you don't have a staff forum, and you feel that union recognition is not necessarily the best way forward for your organisation, you should consider setting one up. Communication is important, both with trade union or other staff representatives, but importantly also directly with your staff, because you then have some control over the narrative about key messages. Don't leave it all to your staff reps or your trade union representatives. Listen to staff feedback and consider what the charity can offer. And if there is a dispute, just be aware that a solution is not always financial. Excuse me. So the dispute might be about pay, but if financial constraints mean that expectations cannot be met, then other offers could be made. So you could consider increased flexibility around hours, or even a reduction in hours to increase the effective hourly rate if services can still be delivered. One of our non-charity clients reached a negotiated settlement on a pay dispute by sticking to their original pay offer, but agreeing to vary hours, so staff worked an extra 12 minutes a day and finished an hour early on a Friday, and that unstuck the dispute. It's also important that you're transparent about the charity's position in communications with staff and the trade union. If you have a secret agenda, it never works. Charities are generally good at sharing their financial position and getting buy-in from staff about the charity's strategy and objectives. And staff are usually really motivated and very supportive. There is, however, an inevitable focus on how often increasingly limited resources are used to remunerate staff and what is an appropriate level for this to be done at. So over-generous rates are not appropriate for a charity, but staff do need to be properly remunerated. And sometimes that's a difficult balance. And staff might not always agree with proposed salary scales when reviewed against market pressures. And that can obviously affect recruitment and retention as well. And if the dispute does escalate, then you should consider using available dispute resolution procedures, such as ACAS or alternative mediation or arbitration mechanisms. So if there's a recognition agreement, as Jo said, the dispute resolution process should be set out in the recognition agreement. And some recognition agreements expressly provide for referral to ACAS. Now, ACAS can seek to assist in resolving dispute, most commonly by mediation, which is a consensual and non-binding process, or more rarely by arbitration, where the outcome is imposed finally on the parties. Even if there's not a recognition agreement for referral to ACAS, then the parties can still ask ACAS to assist, and there are specially trained conciliators who can help. And next slide, please, Romany. So what does the future hold? Well, of course, we don't have a crystal ball, so no one knows. But the cost of living remains high, and there is likely, this is likely to mean a continued pressure on charity employers to engage on pay and work-related subjects. We've seen increased levels of trade union activity across all sectors and a drive, sorry, I got a real frog in my throat, by trade unions to engage more widely and to use disputes about pay and terms and conditions of employment to drive up their union membership numbers and to press for recognition. The CAC, referred to by Jo earlier, saw about 50 applications for compulsory recognition last year, and some of those were from charities. The statutory requirements for elected representatives will continue. So Jo referred earlier to TUPE transfer or the need for collective consultation in relation to redundancies. And the focus on staff engagement is also likely to continue. And there is increasing support for staff, for trade unions from certain categories of staff. They're sort of coming back into fashion in certain quarters. And the provisions relating to the formal works councils, which were set up as an alternative, are to be repealed. So existing works councils will continue, but new works councils, the proposal is, will not be allowed. So there'll still be opportunities to create informal works forums and staff forums. Next slide, please, Romany. So what should you do? Well, there's no one right or wrong answer, as Jo said, and she ran in some detail through the advantages and disadvantages earlier. Certainly, if you do receive a request from a trade union for voluntary recognition, then don't ignore it and hope it will go away. It may be the first step in seeking compulsory recognition, so address it. However, if it is a matter of choice, then having a recognised trade union can be positive in some situations and for some reasons, as Jo summarised at the start of the talk. It can provide an effective way of engaging with staff, not only when statutory consultation is required, but also, for example, to address employment relations issues or introduce changes. Staff may value it, and it might be in line with the ethos of the charity. And for some stakeholders, it may also be an expectation or a positive selling point where supply chains are subject to review against, for example, International Labour Organization standards. Although it has to be said that inevitably in other circles, the converse is also true. But arrangements have to be made for facilities and time off, so there is a cost. Picking one trade union where staff are members of more than one union or not union affiliated may mean that all staff don't feel properly represented. Effective and positive partnership working can be dependent on the individual representatives in place, and that's a matter for the union to decide and not for you as the employer. So that's slight uncertainty about how good that relationship will end up being. So for some organisations, a non-unionised staff forum may be preferable. That's all we have to say this morning. So thank you for your time. If there are any questions, then we will do our best to answer them.
Kathy, I've been keeping an eye on the Q&A box. We've got a couple of questions in. I think one of them you may have covered in your part of the session, but just to reiterate, the question is, we don't recognise a trade union, but can our staff go out on strike? Do you want to cover that one?
Yep. So yes, they can. They still can, and a number of schools are finding that at the moment in relation, particularly to the pension dispute that's going on at the moment. So yes, they can, and as I said, even non-trade union members can strike as well if they're affected by the trade dispute. So that can be a surprise to some employers.
And then we've got another question. We recognise a trade union, but we don't have a clear recognition agreement. Can we seek to renegotiate that and improve it? Shall I pick that one up, or do you want to cover it?
You pick that one up.
I'll pick that one up. It's only fair, you did the last one. So yes, you can seek to renegotiate it, and if it's not working for you and it's not working for the trade union, and you want to have a clearer set of arrangements in place that are going to lead to a more effective consultation and negotiation going forward, then yes, approaching the trade union to seek to put new arrangements in place is appropriate. It may be worth looking at what your existing arrangement says, if you've got provisions about how long it's in place for, what the arrangements are for terminating it. But yes, essentially you can seek to renegotiate.
And just to follow on from that as well, if you have a recognition agreement and it hasn't been reviewed for some time, it's worth actually looking at it again and seeing whether it's still fit for purpose. We quite often get asked to advise on really, really old recognition agreements, and they don't really make any sense or reflect the current arrangements between, just the current employer arrangements, let alone actually how the union and the staff interact. Then one final question, can you recognise more than one trade union? Well, the answer to that is yes. Yes, you can. Sometimes employers don't deal because you're sort of splitting the discussions, and particularly if it's around pay. So yes, you can, but it adds an extra layer of complexity. You can also have joint recognition. So that's where you recognise two unions jointly for the same set of staff, the same bargaining unit. But again, to be avoided if at all possible, on the basis that it just adds an extra layer of complexity, and the unions quite often trade off against each other in, for example, pay talks. If you get yourself into that situation, it's usually better to have some sort of joint negotiating committee, which is as non-union members, and then trade union representatives from the two unions that you recognise. So you take it away from a direct trade union recognition agreement and negotiating forum. Okay. Anything else, Jo?
I don't think there are any other questions that have come in.
Okay, well, thank you all for your time and for listening. We have popped a poll up, so if you would fill that in before you log off, that would be really helpful for us. Thank you all, and hope to see you next time.
Thank you. Bye.